The Chauvin leaks today. Oh, yes. The leaks on the Chauvin trial. The grand jury, that is. The grand jury proceedings. What is happening there? And how we can learn more about it. Hey, Flowtog. Let me just get my setup here. Here we go. So I'm streaming on 2 platforms right now. I've got YouNow. If you want to go to younow.com and participate, you're more than welcome to. Let me turn that off. And hey, Brett. Hey, Kim. Apex Law, Flowtog, Chris, TF, Tater, Steve Ross. How's everybody doing? Hi, Malone. Hi, Malone. Doug, Candy. What's up, guys? Duke Savage. Yeah. Very interesting stuff happening in the world recently. Very interesting stuff. I'm going to try and get this. I'll probably put it right here. It's just I'll be looking away. Hey, Edvin. Hey, John. Welcome back. I like my new mug. Thanks, Apex Law. He says I have the best videos. From Tucson. Right on, man. Chris Abbott. Hello, hello, hello. Let's give people a moment to kind of roll in here. In the meantime, let's do some updates. I know that you guys are not huge fans of TikTok, but I did have a video go viral on it yesterday. Well, Thursday, Friday, and today. It racked up like over 1/3 views in like 48 hours, which is pretty insane. It finally slowed down. It also gave me like 2,000 extra followers. That was wild. I'm almost at 8,400 followers on TikTok. Yay! That place is wild. I like to call it my pigeon brain audience because they are not mature enough to sit through a 1.5 hour long video on YouTube like you guys. But they can, they have enough of a brain like a pigeon to absorb like 60-second worth of content. But it's also good for exposure. I can't dismiss it outright. It certainly has its perks. Oh, give me a second. Somebody just sent me an email. Where do I watch Mr. Foreman's live stream? Oh, come on. Did you freeze up on me? No. Okay. Here we go. That scared me for a second. I'll email you real quick, dog. This is the link. Link to watch. There you go. Send. Thank you for educating the public and helping making a difference. Of course, man. Always. You know me. Commonwealth v. Long. Yes, that is a case, Hi Malone. You know case law. Thanks, Edvin. It's my favorite mug now. Hey, Candy. I'm doing quite well. How are you? Hey, 7 speakers. Thoughts on the Lori Lightfoot's blatant racism? I haven't kept up, but maybe we'll get to that, John. So just remind me later on. Thanks, Flotog. I'm trying. Yeah, the younger generation does have a shorter attention span. So I'm thinking, what better way to reach them than to have a, whatchamacallit, 60-second videos, So it's nice. It works. No complaints. But yeah, we are at 67,000 subscribers. Wow. Wee-wah. Just inching closer and closer to that 100,000 subscriber mark. We'll talk about it, Sub-Zero. Give it a second. James Freeman, I don't know who that is, John. First Amendment auditor, you say? Sounds like it. Apex Law. Ooh. Now, this is interesting. He says, I have used your cross-examination techniques against Arizona traffic cops, and it works great. Tell us more about it, Apex Law. I'm very curious. He says, wish you were licensed here. I'm not, unfortunately. Hey, Peanut Oink. Hey, Nate. Welcome back. Yeah, new, fresh court case content. So my next trial is next Wednesday. Not this Wednesday, but next Wednesday, June 2nd. That one is going to go. It's going to be... the charges are very severe, very serious against my client. It's not just like your good old-fashioned DUI like we have been having up until this point. I mean, we had some cases with like a speeding, a registration, those are nothing. This one, literally, I have 22. At last count, it was 20. Now I have 22 jury trials that I'm going to be doing. And oh my God, let me tell you, we're starting off with a bang. We have a DUI first offense with an aggravator. I actually have to figure out why it's an aggravating circumstance, because that makes no sense. The aggravating circumstances, there are 6 of them. And I'm probably going to have to look into why he was charged as an aggravator, because that really doesn't make any sense. Kentucky DUI laws, DUI aggravators. There are 6 of them. Driving more than 30 miles per hour over the speed limit, no. Going the wrong way, no. Causing an accident, no. Having alcohol, no. Refusing, yes, but that's a first offense, no. Transporting a passenger, no. So I think he got charged with an aggravator because he refused, but that doesn't really apply to a first offense DUI. There's case law on that, and the prosecutor is going to have to amend the DUI to a non-aggravated DUI before we begin the trial. However, and get this, right? So first charge is DUI, aggravator. It'll probably be amended down to a non-aggravator, no problems. The interference with the duty of a peace officer, interference with a peace officer's request to perform a duty, that's a charge. Open container, that's another charge. Resisting arrest, that's his 4th charge. Menacing, 5th. Terroristic threatening, 6th. Improper parking, fire lane violation. Holy guacamole. It's a doozy of a case. I'm really excited about this one. I think it's going to be a very interesting trial, and I want to see what jurors are like in this post George Floyd arena, because I think ever since George Floyd has been killed and Derek Chauvin, which we'll get to in a moment, Derek Chauvin's trial has been concluded, and now we have the grand jury proceedings against these other cops who are also responsible, allegedly. You know, the scene, the criminal law scene, the jury scene is going to be very, very different. I mean, jurors will never be, hey, Richard, jurors will never be the same, and their decisions will never be the same, because now cops are painted in a different light, and not a very positive one. We've had, I don't know if it's the first time in history, but we had a cop convicted of murder, manslaughter, and second, manslaughter, third, you got the full shebang. And that sent a message to cops across the country, not just for killing people, but it also sent a message to cops for, their behavior in other circumstances. So this happened in 2019, the case that we're going to be trying in 10 days. But the interesting thing is the ramifications of this arrest and him mouthing off to the cop. That is going to have some serious implications on this case today. So if this case had been tried in, let's say, I don't know, February 2020, hypothetically speaking, then it would be seen in a completely different light. I'm talking, of course, pre-protests, George Floyd, pre-Breonna Taylor, pre-everything. And the trial is going to be in person, Saul Miller. I'm fully vaccinated now, and hopefully, and I got my card so I can show it to the court, unless I'm sure they're going to believe me on the honor system. And plus, everybody's already seen it on social media, so there's not really going to be a question of, is Mr. Foreman vaccinated? I kind of had to for a couple of reasons. One, I don't want to be wearing a mask or a face shield, because I think it obstructs my view of the jury. It obstructs my face. They can't see my full range of emotions. I know a lot of you guys don't approve of it. I read your comments, by the way, on that post that I made of me wearing that mask, me with the vaccine card, getting fully vaccinated. I knew you guys wouldn't approve, but I posted it anyway. You know why? Because I really don't care about your opinion. No offense. I really don't care. Hey, Charles Robbins, welcome to the channel. He's watching on you now. I really don't care about your opinion. Sorry, not sorry. But I wanted to hear it, and I was curious. It literally generated like 80 comments within like the first 2 hours. So it was pretty funny. So I don't want to. And the other thing is, now we're going to have jurors that are going to be very. We'll get to it, Charles. By the way, thank you for joining us. I know that you're just joining us. We'll get to the Chauvin thing in just a moment. The jury pool. I mean, we're going to have a very, very different type of jury pool, because a lot of elderly people are going to be, not in the jury pool. They may still be afraid to come out. Just because everyone's getting vaccinated does not necessarily mean that the people that are over 70, over 80, over 90 are going to feel comfortable, coming out and going to the courthouse to be surrounded by people, even if they are sitting somehow, 6 feet apart, which I don't even know if is going to be mandated anymore. Because the Supreme Court of Kentucky, Chief Justice Minton said, I can actually read it to you guys, because I think it's phenomenal. This is the summary. We're not going to read the full thing, but basically, Administrative Order 2021-16, which was issued exactly 4 days ago. So this is fresh stuff. This just happened. It allows in-person access to court facilities for any individual with business before the court, except if you have been tested positive or exposed to COVID-19. Basically, you can come to the courthouse in person, no problemo. This is from Big Guns upstairs, the #1 guy here in Kentucky. Number 2, it eliminates the mask requirement for fully vaccinated members of the public entering court facilities and fully vaccinated KCOJ elected officials and employees. Eliminating the mask requirement. Boom. It's gone, right? if you're vaccinated. Strongly encourages continued use of masks who are not vaccinated. So if people are not vaccinated, permits judges to require encourages this one I absolutely love because it's really going to help us practice and get more cases rolling. Encourages the continued use of remote technology for court proceedings and allows any individuals with scheduled remote hearing to appear remotely, and allows judges to conduct in-person proceedings, allows filings and payments to be made in person. Now, the next one, 2021-17, is super nice. Super nice. Lifts most restrictions on jury trials, but requires continuances, postponements, and recusals for attorneys, parties, and jurors who are ill or an increased risk of severe illness from COVID-19. So anybody in like the severe risk category, like Saw Miller Smith says, I'm 72 and followed no COVID-19 recommendations and no vaccine. You're a risk taker, Saw Miller, and you're definitely in the minority. You know, if you're over 60, 65, and you don't want to come to court, when you get that jury summons, you just say, F you, I'm not coming, and that would be the end of it. I mean, what are they going to do? Force you? Come on now. That's not going to happen. Eviction court is, if it hasn't already, I believe it started in full swing on May the 1st, if I'm not mistaken. So it's lots of interesting stuff happening. So pettit jurors, jury trials may resume if the trial judge determines in his or her discretion after having considered local public health conditions and the health and safety requirements established by the Supreme Court in Administrative Order 2021-16 that it is advisable. Attorneys shall be granted a reasonable continuance if they or their clients are ill or at an increased risk of severe illness from COVID-19. And interestingly enough, by the way, my client that we're going to be, oh no, I'm sorry. No. That's not this case. That's not this case. He's fairly young. He's like 40 or something. But anyway, that's basically updates. What if I want to bring my video camera mobile phone for documentary purposes? Real Jingy. Where are you talking about? To the courthouse? That's fine. I mean, media is in the courthouse all the time, especially when there's like the most notorious cases, of course, like child molestation, child rape, incest, sexual allegations, like all of those. Those the media just eats up like by the spoonful. Even when there's like an arraignment, I mean, they're there. They're just, I don't know what it is with the media fascination. What is the public's fascination with sex offenders or alleged sex offenders? I mean, I get it, but I don't get it. I mean, does it really make for good TV? I mean, that and murder. So if you touch kids or you kill people, you're going to be on television, basically, guaranteed. You know, that kind of goes without saying. I mean, we've all seen it. So for you to bring your own video camera, mobile phone to document whatever you want to document, Real Jingy, as long as you let the judge know ahead of time, I highly doubt, because courtrooms are public forums. I mean, obviously, you guys know, all of my trials are posted on YouTube. Not all of them, but a lot of them, I should say. So obviously, these are all public. It's not a secret. Actually, secret trials are forbidden and prohibited in Kentucky. And not just Kentucky, I think the United States. I mean, you guys remember Edward Snowden and the FISA courts, the secret courts that are issuing warrants with no probable cause whatsoever just because they're alleging terrorist activity. Those allegedly, have been done away with, but for the most part, they really have not. I'm sure they're still around. They're more on the down low, so there's not as much exposure to them. But how's it going, C Perceptions Music? He joined us on You Now. So yeah, if you are so inclined, join us on You Now. I think you can like donate stuff and whatever's. If not, no big deal. I'm surviving pretty well. Business. Some of you might be wondering, business is booming. Monday. Oh, grand juries are always secret, John. Grand juries are always done in secret. Well, actually, this is a good segue. I'll get to the grand jury with George Floyd's death. So first of all, we'll explore the topic of grand juries, what it is, how it works, etc. And then we're also going to be explaining what happened here. So I have not researched this topic ahead of time. I'm giving you guys a full heads up. This was intentional. I want to delve into it fresh learn about it fresh, and basically be in the same boat as you guys and give you my legal opinion moment to moment as it evolves. So you guys can see the thinking process and so on top of everything. So jury trial, June 2nd, super exciting stuff. And what's the next one? So we got June 2nd, June 9th, June 11th, June 17th, June 23rd. Those are my first 5, I guess. Yeah, 5 jury trials. And then we got more in July. 1, 2, 3, 4 in July. 1, 2, 3, 4, 5 in August. 3 more in September. I mean, it's wild. I mean, it's absolutely insane. So, and I still have like 5 more jury trials in the pipeline to add more insult to injury. So, without further ado, let's talk about the Chauvin, George Floyd grand jury situation. So let's talk about grand juries in general. What are grand juries? So when you think jury, 99% of people, when they think jury, they think, oh, 6 men and women or 12 men and women deciding the fate of a criminal defendant or deciding how much money to award in a civil case. And 50% of the time, you're right. That is called a petit jury or petite jury. Nobody really pronounces it petite, but it's spelled like petite only without the E, P-E-T-I-T. Petit juries are your classic juries that you see on TV. They're the ones that are, basically the ones that we're all familiar with. They're the ones who decide fate, the ones that decide money, and so on and so forth. However, grand juries are a totally different beast. Here's what they are. Grand juries are always done in secret. The location of where they are to be performed is undisclosed. 12 Angry Men is what comes to mind, by the way. You're absolutely right, See Perceptions Music. Are you in both places? That's pretty cool. So yeah, that's what you think about. That's a petit jury. 12 Angry Men is petit juries with Henry Fonda. Now, or The Verdict with Paul Newman, another classic one. My Cousin Vinny was a petit jury. Grand jury, and I'm trying to think if there's any. I can't even think of any Hollywood reference that directly talks about grand juries. Like, nothing comes to mind. I'm trying to think very hard here because they don't come up. They're really not as exciting as petit juries, because petit juries, you put on evidence and you got both sides. You got Law and Order. Charles Robinson on YouNow says Law and Order, but barely. So there you go. I'm not very familiar, I don't follow Law and Order, but in Law and Order, you're going to have, grand juries. There you go. There's your example. So your grand jury is meeting in secret. So here's how lopsided grand juries are. First of all, they meet in secret. So you don't know the date, you don't know the time, you don't know the location. That's just right out of the gate. Number 2, the only people who are going to be present 99.99999% of the time are just the prosecutor and his witnesses. That's it. In 0.0001% of the time, the prosecutor may ask your client to be present. Now, interestingly enough, you cannot be there. You cannot be, as the defense attorney. You cannot be inside the room when your client is being questioned. My law professor put it quite eloquently. He said, if you want to advise your client on being on a grand jury, the best way you can do it is having him literally walk out every question that is being asked. I mean, that's not going to look fishy at all, right? But that's basically the only way. I'm sorry, I'm trying to fix my tie here. It seems a little crooked. I'm not even sure if I can get it, but whatever. It just seems very, very askew. But I'm sorry. My arm still really hurts, so I'm trying to get as comfortable as possible from the COVID shot. But anyway, so yeah, grand juries are very suspicious, but they're real and they're okay because so once your case in district court is being waved up to the grand jury. Grand jurors decide whether or not you get indicted, and they, if you get indicted, I don't remember if they have to be unanimous. I don't think they have to be unanimous, as long as about usually there's about 15 to 16 of them. Thanks, C Perceptions Music. Usually there's like 15 or 16 of them, and they, as long as I think 10 of them agree or something like that. I honestly don't remember the exact number. It's been a while since I looked at the literature, since this is not something that you typically ever, like I said, I'm not even allowed in the room. So what the heck do I care how many of them decide? I mean, of course, if they're under the requisite number, but I've never had that issue. So basically, that's what they do. They decide whether or not your client gets indicted. It's a very easy, very quick process. And yes, Justin Casieta, I do pro hack Vici. So yeah, don't forget to like this video, comment below, subscribe to the channel, hit that notification bell, or join on as a member. I have shared some very, very private stuff if you are a honorary lawyer member of the channels, and there's going to be lots more coming. So be on the lookout for that. It's actually really, really cool stuff. There's going to be lots more insider stuff to share. So so that's grand juries. The only people who really testify is usually you have just the investigating officer. He lays out, or she lays out, the facts. The prosecutor asks them the most leading questions in the universe. Usually they omit lots of different information. I mean, I'm personally a witness to a police shooting case that we are currently litigating. It's in the appeals stage. And I mean, point blank, the prosecutor intentionally omitted showing the grand jury the video of the incident. I mean, talk about one-sided. I mean, he's buddy with the cop, and everybody knows that. And they intentionally omitted showing the jury the video because the video could have landed the cop with some criminal charges such as manslaughter, possibly even murder, because there was a point-blank range shot. The video is on the channel if you guys are curious. And no indictment. Absolutely no indictment. Why? Because the cop, the investigating Kentucky State Police officer, not only lied about the investigation, he also never showed the jury, or the prosecutor never showed the jury, the actual freaking video of what happened. So very, 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 very fishy stuff. But it happens all the time, unfortunately. So let's talk about, finally, let's dive in. Welcome, Die Young 1717. Joining us on YouNow. We have almost 200 collective people watching. This is pretty awesome. So let's talk about today's topic. Federal judge investigates leak. This happened yesterday afternoon, yesterday at 2 p.m., so about a day and a half ago. Federal judge investigates a leak of grand jury proceedings into George Floyd's death. This is the first article I found, Star Tribune. Two newspaper stories describe the possibility of federal charges for Minneapolis officers. Derek Chauvin, J. Alexander Kuhn, Thomas Lane, and Tao Thao, the four officers involved in George Floyd's death. So what is going on here? A federal judge has begun an investigation into leaks to newspapers about the secret, there it is, right there. Hey, Scotty's side. Secret grand jury that indicted 4 former Minneapolis police officers on charges of violating the civil rights of George Floyd. So I'm guessing they're probably talking about the grand jury proceedings that happened months ago, and they're being leaked. Usually it's an audio tape. At least in Kentucky, it's an audio tape. They don't have video of these grand jury proceedings, again, because they have to record something. I think some places don't even record. They just kind of write it on a piece of paper. But in Kentucky, they do record audio. So if your client gets indicted, you will always have access to that audio tape. U.S. District Judge Thomas McNulty says Chauvin deserves a new trial. If you're talking about that one juror that was like a Black Lives Matter activist, I disagree. That's still 1 out of 12. 1 out of 12. And that's not enough to overturn a verdict. So the other 11 were not Black Lives Matter activists. And they all agreed unanimously to convict Chauvin. What about the leak about the Chauvin attempted plea deal? So that's a great question too. A plea deal, I mean, you can always try settlement negotiations, plea deals, and so on without any adverse effects on your case, because the law basically says, look, it encourages deals, it encourages settlements, and if those were like, those cannot be disclosed to a jury. If there was like a consideration of a plea deal, the jury will never know about it. If there was a consideration of settlement, the jury will never know about it. I mean, think about it. If you're just trying to settle just to get the case over, and then your balls are in a vice just because now that you've attempted to settle, now the jury's going to know, and they're going to infer guilt or liability. You know, I mean, nobody would ever want to settle ever, anywhere, under any circumstances. You know what I mean? Thanks for becoming a fan, Charles Robbins. So let's read on. U.S. District Judge Patrick Schiltz ordered the U.S. Attorney's Office and the Minnesota Attorney General to provide a list of every person to whom they disclosed grand jury activity. Uh-oh. So basically, everybody who has a copy of the tape is now going to be under investigation, and they're going to find the culprit. Larry, in states where there's not a grand jury system, how are indictments and charges formally brought? Either by information, or they're just waved upstairs without skipping the grand jury. I think the grand jury system is available in every state. Now, some countries might be different, but states, I think it's available in all. The same judge also ordered the U.S. Attorney's Office to explain why he shouldn't appoint an independent prosecutor to investigate. Oh, my God. I am creaming in my pants right now. He also ordered the U.S. Attorney's Office to explain why the judge shouldn't appoint an independent prosecutor to investigate and file criminal contempt of court charges for the disclosures. Wow. Schiltz wants the responses filed under seal no later than June 4th. That's pretty big, folks. That's pretty big. An independent prosecutor to be investigating this, looking into this, and trying to leverage charges against people. I mean, that is absolutely phenomenal. At issue are stories published by the Star Tribune and the New York Times detailing the possibility of federal charges against the former police officers in Floyd's murder. On April 29th, the Star Tribune, this is the article that I'm reading, the same newspaper of the article that I'm reading, the Star Tribune published a story with the headline, Feds plan to indict Chauvin, 3 other ex-officers on civil rights charges. On February 23rd, the New York Times published a story about the grand jury with the headline, with new grand jury, Justice Department revives investigation into death of George Floyd. The New York Times story came out days before the beginning of jury selection in the state trial of Derek Chauvin, the officer who knelt on Floyd's neck and was convicted in April of second-degree murder, third-degree murder, and manslaughter. Former officers J. Alexander Kuhn, Thomas Lane, and Tao Thao faced charges of aiding and abetting second-degree murder and manslaughter. The 3 are scheduled to stand trial in state court next March. So we got about 10 months for that. Until that happens. Days after Chauvin's conviction, the Star Tribune story revealed that the Justice Department had been working to indict him on federal charges, and if he had been acquitted in state court, which he was not, the feds planned to arrest him at the courthouse, citing an unidentified source. Okay, but Chauvin was convicted on May 8th, and the 4 former officers were indicted by the federal grand jury. In his 5-page order signed May 5th, Schiltz cited the U.S. Supreme Court's reasons for protecting the secrecy of grand jury proceedings. For example, preventing the escape of those indicted, influence on deliberations, perjury, or jury tampering. In order to safeguard the secrecy, this is a direct quote from Judge Schiltz, in order to safeguard the secrecy of grand jury proceedings, federal prosecutors are generally prohibited from disclosing matters occurring before a grand jury. In this case, federal prosecutors were given permission to provide information to Attorney General Keith Ellison's office, which is handling the prosecution of the 4 former officers. Okay. Ellison's office then was prohibited from disclosing the information for anything other than investigative or prosecutorial reasons, Schultz noted. Jane Kirtley, professor and director of the Silha Center for Media Ethics, and Law, said Schultz appears to be conducting an investigation to find the source of the leaks without compelling journalists to divulge their sources. I really like that. Because, you know, if you're a journalist, your number one obligation is to whom? Definitely not your public. It's to your sources, right? You got to protect your sources. And by going after, conducting an investigation and trying to find out on their own, rather than going after the media, this is kind of like a backdoor way of finding out who the source is without having to force journalists to sacrifice basically their professional career. So that's really nice. There's always the risk they'll conclude they have no recourse other than to go to the journalists, but let's hope that doesn't become necessary. Star Tribune managing editor Suki Dardarian said, I have no comment on the court's actions, but I will say that the Star Tribune stands resolutely behind its pledge not to reveal the identity of anonymous sources. And a spokeswoman for the New York Times declined to comment. It would probably be something similar, I would imagine. A similar leak investigation is playing out in state court, where Hennepin County District Judge Peter Cahill suggested that attorneys for all the parties file sworn affidavits attesting that they weren't the source for a New York Times story earlier in February. Cahill did not order that they must file affidavits. Suggested. So he didn't order, but he suggested. That's interesting. So if you don't file it, you kind of like out yourself, I guess. I'm not really sure. And if you, file an affidavit and later turns out you were the leak, well, now you can be charged with perjury. So it's kind of nice. It's kind of nice. In that story, no, Blue Ridge Bikeman, the number one obligation is to its sources. Number two is to its editor-in-chief. Number three, the journalist probably has an obligation to the people they're doing a story about. And then finally, number four is the readers. Sorry. In that story, the Times cited anonymous sources in reporting that in the days following George Floyd's murder, Chauvin was prepared to plead guilty to third-degree murder and go to prison for more than 10 years, but then U.S. Attorney General Bill Barr rejected the deal. In a hearing in the state case last week, a frustrated Cahill said he first asked attorneys in February to voluntarily file affidavits and was disappointed that only Assistant Attorney General Matthew Frank had complied. Cahill strongly encouraged attorneys last week to follow suit, prompting Frank and Assistant Hennepin County Attorney Joshua Larson to say they would provide affidavits for their offices. Many attorneys have submitted sworn and notarized affidavits. Many attorneys have submitted sworn and notarized affidavits in the state case. Hennepin County Attorney Mike Freeman, however, submitted a general letter stating no one in his office was the source of the leak. So he's kind of avoiding the whole affidavit requirement. How's it going, Theme and Jay? Freeman's office said Friday they will not file a sworn affidavit. The Hennepin County Attorney's Office has informed the court that our office was not the source of any information leaked to the New York Times. Okay, so everybody's denying liability. Said a statement from Freeman's office. Whether it is in the form of a letter or affidavit, County Attorney Mike Freeman has addressed the issue personally and on behalf of his office. At this point, our office feels that we have satisfied the court's request. Ellison filed a sworn affidavit Friday. Ellison spokesman John Stiles said Friday they would also file affidavits in the federal matter. A spokesman from the U.S. Attorney's Office declined to comment. So what are they going to do? Are they blaming or suspecting that it's going to be the defense lawyers then? Because unless I missed something, all of the affidavits so far seems to be the Hennepin County Attorney from the Hennepin County Attorney's Office, Assistant Attorney General Mike Frank's office, Mike Freeman, like I said. So what are they? They're probably trying to say that this was the defense's work, I think, if I'm not mistaken, unless I missed something. To me, this sounds like they're trying to, but I mean, they can't prove it. Again, they cannot prove it. But maybe they're trying. I'm not 100% sure what the dealio is here, but that's pretty crazy. That's pretty crazy, especially because the leak. I mean, you got you got to remember. Nelson and Associates filed his affidavit. Oh, is that in the article? I'm sorry, I may have missed it. I didn't see that. I didn't see that in this article. Maybe it came out later. I just searched for it. And it's very interesting because, you know, obviously somebody leaked it. Obviously it came from somewhere because Richard. Yeah, I mean, listen, this is real talk. I don't on these live streams, you guys know me. I'm not going to sugarcoat it. If I feel something, I'm going to tell you guys. You know, so who's left, right? The grand jurors don't have access to this information. The leak came days before the trial, which is maybe somebody can try in the court documents. Okay. So maybe somebody can try and the problem with leaking that information, and this is where I see why asking for a new trial with those leaks right before trial about him trying to take a plea deal is very, very important, is because, you know, if those pettit jurors going into jury duty trying to decide his fate, if the allegation is going to be now that if in any way, shape, or form the jurors had full knowledge, at least one of them, that Chauvin was going to take a plea deal. Only guilty people plea. That's the most common misnomer, because a lot of innocent people plea just to get the case over with, and a lot of people plea just because they think that they're going to get a better deal if they plea versus if they go to trial. I mean, there's something called an Alford plea, and that is when it's based on this case from the 1970s, I think. Mr. Alford was accused of murder, and he did not do it, but he said there's so much evidence to prove my guilt that there's no way I'm going to win this. So he pled pursuant to what's known as an Alford plea. And an Alford plea basically means exactly that. I maintain my innocence, but I plead guilty just because I think I'm going to get convicted and creamed anyway in court. So it's very uncommon, but it does happen. And when it does happen, the legal ramifications of an Alford plea are essentially null. That's the same as a conviction. It doesn't make a lick of difference. However, it does give you the opportunity to argue to like a potential employer, like, look, I pled pursuant to Alford. I maintained my innocence at the time I pled. So that's really the only benefit of it, in my opinion. But yeah, so yeah, that's let's take a look at some more articles about the Chauvin trial leak. Main players, here we go. This is from the 18th of May. This is a few days ago. Main players in Derek Chauvin's trial swear they didn't leak to New York Times. Several key figures have all sworn that they did not leak information to the New York Times about the failed plea deal negotiations. The New York Times reported in February that a plea deal was on the table back in May 2020, but then Attorney General Bill Barr rejected it, right? This is what we were just talking about. Assistant Attorney General Matthew Frank, Chauvin's defense trial lawyer Eric Nelson, and 5 others involved in the trial have filed affidavits to say that did not leak the information. There it is. Among them was at least one lawyer involved in the case against the 3 other officers involved in George Floyd's death. Nelson's affidavit included emails showing him declining to comment on the Times story. Hennepin County attorneys, Mike Freeman, we said, wrote a letter. In the hearing last week, Hennepin County District Judge Peter Cahill demanded prosecutors file affidavits after admonishing those involved in the leak and making it clear he believed it came from the Justice Department. He said, right, because here's the thing. Who benefits from the leak? I'm going to open this question up to you guys. Who benefits from this leak? The leak is, again, came in February from the New York Times that Derek Chauvin is looking into pleading guilty and taking 10 years in prison. That's the article. This is 3 months before the jury presided and convicted him. Who does the leak benefit? We're going to open it up to you guys, to the audience. Who does the leak benefit? The prosecution or the defense? What do you guys think? Oh, come on, Kim. You can't give such an answer, defense or prosecution. Come on now. That's okay, Theme and Jay. I want to get some perspective. Most people are saying defense. But why? Why do you think it benefits the defense? Okay, now we're about an even split. Those of you saying it benefits the prosecution, learning the ropes, we said that what leaked was Derek Chauvin's potential guilty plea deal back in 2020. It helps the defense to give him an extra out if he was found guilty. That's interesting. Hey, Aaron D. Priska. He says I got a DUI last week. I'm sorry to hear that, brother. If it happened in Kentucky, I'd be more than happy to assist you. I'm not laughing at you. I'm just laughing because you came in here because you saw my name as the DUI guy. And I'm guessing you might be looking for representation. Where was it? Where was the DUI? Which jurisdiction? An extra shot at appeal, says Kim. You know what? I actually did not consider that. Texas. Right on, man. Call Mimi Coffee. M-I-M-I. I'm going to type it out for you. Mimi Coffee. And tell her that the DUI guy sent you from Kentucky. She will take care of you. She is the number one DUI lawyer in Texas. Mimi Coffee. Her tagline is DUI at night, coffee in the morning, which I think is great. But anyway, so the judge believes that the Justice Department leaked it. Why does the judge believe that the Justice Department leaked it? I think, yeah, no problem, Aaron. Good luck to you, and welcome to the stream. Hopefully you can stick around. So why do they think, why does the judge think that the Justice Department is the one that leaked the information? My opinion, because it helps them convict Derek. That's the obvious one. That is the obvious one. They leaked it because if the jurors are under any suspicion whatsoever that Derek was going to take a plea deal, that basically crucifies him right there on the spot. I mean, he loses before he can even open his mouth, right? Because, again, the common misconception is only guilty people plea. It's not true. Only liable people settle. Also not true. But that is the most common misconception, and it's just that's what it is, and that's what life's all about, is misconceptions, unfortunately. Now, despite this fact, Kim brings up a very, very good point. Maybe it was the defense that leaked it. Why? because now the defense, if they lose, on the off chance they lose, they now have a very, in my opinion, this right here is a very strong appealable issue. I mean, the whole talk about the one juror who was a Black Lives Matter activist and didn't disclose that during the trial. I mean, come on, that is horse shit. That is not enough in any stretch of the imagination to be able to overturn a guilty plea by 12 men and women. 11 other men and women voted Chauvin guilty on the 3 charges: murder second, murder third, and manslaughter. So I don't know. This one is a lot stronger. What's up, Adrian Smith? This one is a lot stronger. This one is a lot stronger. Because if they can show that the leak has, in some way, shape, or form, and I think this can be fairly done in a brief by the defense, they're going to file an appeal, and they might win if they can show that the jurors were swayed by news of the guilty plea deal. Now, but then the other question becomes, how on earth, now that the whole world knows about this plea deal, how on earth can you get a jury, even if on the retrial? How do you get a jury? That's the prosecution's argument. Where do you find a jury that doesn't know about his potential plea deal and doesn't know about the fact that he was convicted on all 3 charges? Everybody knows. So he's really stuck between a rock and a hard place, again, due to the notoriety and the media presence behind this trial. So having a very, very highly publicized trial has its benefits, but it also has its drawbacks. So that's basically it. He said, and this is Hennepin County District Judge Peter Cahill, said he was even considering dismissing the case against the other 3 officers. Wow. If it turns out that the other prosecutors were the leakers. Well, that makes sense. I mean, that makes sense. If they leaked it, that's just going to destroy their case against the other 3 cops. Just like we just talked about, Chauvin is the martyr. He's the one that takes the fall and everybody else walks away. The Times reported that the plea agreement, which was contingent on the feds not pursuing civil rights charges, was rejected because Barr was worried it would look too lenient amid national unrest over police brutality. And now, of course, as you all know, when is Derek Chauvin's sentencing date? Sometime in June, isn't it? Chauvin sentencing date. June 25th, so about a month from now. Yeah. And he can get sentenced to up to 40 years, in my opinion. He can probably, that's my guess. That's my guess. Oh man, null context, that's brutal. He says, if the knee don't fit, you must acquit. Come on, man. Have some sympathy. Jeez. There's no way to prove who leaked. Well, hopefully they'll find it. And again, worst case scenario, Shannon Johnson, SR, senior. What are they going to do? They're going to go directly to the media and be like, cough it up, journalist. And what do you think a journalist is going to do when, I mean, they might file for an injunction, maybe ask for a gag order on the judge. I mean, they can try all sorts of things, but when the judge is threatening to lock you up unless you cough up a source, they might be stuck between a rock and a hard place. And then we'll definitely find out who the leaker was, but hopefully it won't resort to that. But I think he'll get about 40 years. That's what I'm thinking. I think he's looking at more than 40. What is the maximum that he's looking at? Maximum sentence for Chauvin. I mean, I said 25. Yeah. Oh, 40 years. It is the maximum. Sorry. I remembered now. I think he's not going to get 40. He's going to get 25. That's what I always thought. Remember, I told you guys, I think he's looking at up to 40. He's going to get 25, and then he's going to end up serving like 7 of them. Hard time. So Thomas Talleyrand, look, you can have whatever opinion you want of it, but the jurors have spoken. So if you believe that he died of opioids, he's talking about George Floyd, of course. If you believe he died of opioids, you're entitled to that opinion. But the majority of the country disagrees with you. Apex Law says, Larry, I'm ready to go to law school. Good luck, buddy. Best of luck to you. So I think we're going to get ready to wrap it up here. I do want to open the floor to questions, though. What sort of questions do you all have? Jay Brooker says this chat does not pass the vibe check. Maybe. I don't know. You know more than me. Chat is way smarter than streamer, always. Because you guys are the collective hive mind. There's almost 200 of you watching right now. At one point, we even crossed the 200 mark. I think we're up at like 220 or something like that at one point. And Adam Val, I'm going to be doing a lot more of these now since I basically ran out of topics. I have nothing else left to talk about. So what I'm going to be talking about moving forward is we're going to do current events. And probably going to be doing it twice a week. I haven't really decided what day of the week. I may just be choosing them randomly depending on my schedule. Apex Law asks, are you hiring? Are you in Kentucky, Apex Law? Well, actually, it's funny because Brett, are you still in here? Are you still in here, Brett? Because he actually messaged me on YouTube asking for a position, and I was like, well, I wasn't considering hiring you, but now that you applied and you seem like a pretty chill dude, he got the job. He works for me now. He was on vacation. I don't know. He might still be on vacation. He was on vacation Thursday, Friday. He's been with our office for a couple of weeks now, so he's a good guy. He's a good guy. So I am potentially. Oh no, if you're in Tucson, unless you're planning on moving to Kentucky, I'm not going to be messing around with that. But if you're moving to Kentucky, by all means, I will consider hiring you for whatever position we have open. Right now, the position that we have open is a client intake specialist or client specialist. Both basically the same thing: client specialist, client intake specialist. Just two different names for the same thing. This is the share job. Wait, how can I? No, I don't want to do that. Discard. No, that's not it. How do I? Go to settings? No. Share job. This is the job that we have an opening for right now. It's going to be in-house, so it can be done remote. This is it. The link I just shared, the LinkedIn jobs, that should work. Let me know if that link doesn't work. It's called client specialist or client intake specialist. Yeah, client intake specialist. And it's full-time. And it will pay very nicely, and I think you would have a lot of fun. Don't forget to like this video, comment below, subscribe to the channel, hit that notification bell, and join on as a member. Lots and lots and lots and lots and lots of new content coming. So, all right, let's go back to questions. Does a preliminary examination conference oftentimes take the place of a grand jury? So prelim starts before the grand jury process. Or does a pre-examination conference allow the defense attorney to be present as opposed to grand jury? So if the judge does not find probable cause at the preliminary hearing, then the case never goes to the grand jury and it usually gets dismissed. How does sentencing happen? The judge decides the penalty, or the jury, depending on what jurisdiction you're in. In Kentucky, the jury decides penalty. So sentencing usually happens immediately after jury trial, whereas, I mean, not always. Circuit court, you usually get it passed, but district court, sometimes the jurors will decide it right then and there. Was it smart for Chauvin not to speak during the trial? I think so. Asserting your right to plead the fifth is always prudent, but maybe sometimes not the best option. In this case, obviously, it didn't work for him. Is Sweet James a fraud? I don't know who Sweet James is. Do you go wild dancing? Do you do wild dancing? Is that how you got the TikTok followers? How did you know Thomas McNulty? If you're asking for legal advice, spiritual toast. Hello, Ms. Mini 0308. Welcome to the stream. We're actually wrapping up here, so feel free if you have any questions, by all means. Plane crash last night in Myrtle Beach. He has an ex-wife and a girlfriend, 2 kids, including brother-in-law. His ex-wife was trying to take his stuff. But so this is Myrtle Beach. Email me, spiritual toast. If somebody could please, one of my mods, post my email for Mr. Spiritual Toast, please. Hi, Notorious One. You're in here just in time as we were wrapping things up. Money to ever consider refiling? Money to even reconsider filing the charges on a state level since the feds are going? I don't know. That's half a question. I don't know where the rest of it went. Thank you, Elise. Yeah, I love Paducah too. What kind of special considerations are made for placement of prisoner that was a cop? That's a great question. They're going to be in isolation 23 hours a day, just like he has been to this point, so he doesn't get killed, shanked by the prisoners that are. He's basically going to be one of the guards. He's going to be buddy with them. Do I have someone answering the phones at night? I do, Kim. 24/7. Lori Loughlin case. Oh, is it wrong? It is wrong to love your kid is a viable defense. Lori Loughlin was a moron. You're talking about the college scandal, I think, right? That was just, ugh. We'll talk about it at some point. She deserved her, was it 2 week jail sentence, I think, or wait, no, hold on. What am I saying? Didn't she get like 2 or 3 months? I forget. Was it smart for the lawyer to have him writing notes every second during the trial? No. Can grand jurors speak or leak to the proceedings? I don't think they could because they never got a copy of it. They were present and they wouldn't know anything about the plea deal negotiations. Can a really well-written motion for discovery turn around a waffling anxious DA? Maybe. Thanks, Flotog. Is Henderson, Kentucky a difficult place to argue? Not if you hire me. Second dose, Vashuda Sharma. 2 months. Yeah, she got 2 months, Lori Loughlin. Have I ever worked with the FBI? No. Theman J asked on you now. So I think this is going to conclude our stream for today. I wanted to thank each and every single one of you for joining us. It's been a pleasure. Now that I've run out of content, this is going to be very relaxed, very fun, and every time it's going to be something completely different depending on the current events. I think some days are going to be absolutely fascinating. Other days may be not so fascinating, but we are definitely going for at least 1,000 concurrent streamers The closest I've come, I think, was about 450 during COVID. Now that COVID's behind us, I usually float between the 200 and 300 viewer range. But because I'm doing current events, I'm hoping that viewership is going to increase, and I'm going to continue doing all of this for you guys. So I'm going to try and stream twice a week now. So you will see me, you'll see more of the DUI guy. You will definitely be seeing me on Saturdays at 6:30 p.m. Eastern, 5:30 Central, 4:30 Mountain, 3:30 Pacific, as always. And then the other time slot will probably be variable. I mean, if like some crazy news breaks out Sunday or Monday or Tuesday or Wednesday in the legal world, then I'm definitely going to. I lost my train of thought. Sorry, I'm very exhausted. It's been a very long week. But anyway, Flow Talk says, let's work on a 500 first. Negative, sir. I'm shooting straight for 1,000. Aim high and dream big, folks. Remember that. 100,000 subs may happen before we get 1,000 live viewers. I disagree. It all depends on how much. Well, actually, you might be right. With the content I'm about to pump out, we may get to 100,000 subscribers by the end of July. That's my prediction. Like beginning of August is going to be. Yeah, I had a Biden moment. I enjoy making in the thing and the stuff. Yes. My fellow Americans, the camera and the YouTubes, yes, we will be next week in the Saturdays after somewhere in 6:30. And yeah, all right, folks. It's been a pleasure. Thank you all for joining. I will definitely see you all next Saturday. And I am going to see you all sometime during the week. If y'all need me, email, call, text. I'll see y'all later. Take her easy. Bye-bye.